everyone. Today we will discuss the topic of moral rights in the workplace in Chapter 6. The objective of this chapter is to distinguish the employee rights, examine arguments supporting an employee right to workplace, explain and examine various meanings of a right to work, distinguish the employment at will, examine arguments supporting an employee right to due process, examine arguments supporting an employee right to participation, examine arguments supporting an employee health and safety, examine arguments supporting an employee right to privacy. Framework. Work is a vital and highly valued human activity since it is required for the acquisition of other essential human commodities, because possibilities to work might be compromised by the acts of others. Labor and moral rights are linked. Employee rights. In the workplace, there are three types of employee rights. 1. There are legal rights that are granted as a result of legal or judicial decisions. 2. They have rights that are based on agreements with their employers. 3. There are rights that we have as entitlements as a result of our human status. Rights in the workplace. Keep in mind that rights cannot be purchased, sold, or taken away by force. Legal. Derived from statutes and court decisions. Contractual obligations. Agreed in good faith or in accordance with a policy or process. Rights in the workplace. Respect for human beings is a realm of moral rights in the workplace. Freedom, equality, and autonomy. The rights equation. Greater the rights, greater the obligation. Right to work. The first definition is based on a worker's obligation to join a labor union. This is done to prevent free riders from taking advantage of the system. By the way, free riders, those who enjoy the benefit without contributing. Collective bargaining perspectives are seen as a means of balancing power in the workplace. Who should provide a job? The ones who provide a job are private industry and the free market, government, and safety net. Private industry. Individuals or private organizations control a portion of the economy that is not subsidized by the government. Government. The public is drained by government employment. Safety net. Unemployment benefits. Tax incentives for hiring welfare recipients. Employment at will. Trade-off for the elimination of slavery and endangered servitude. Employee free to quit, employer free to hire for good cause, for no cause, or even for cause morally wrong. Due process in the workplace. Employees' right to be protected from the arbitrary exercise of managerial authority is referred to as due process in the workplace. To ensure that dismissal is not arbitrary, procedures must be implemented. The best argument in favor of an employee's entitlement to due process is based on the ethical principles of respect and fairness. By articulating just cause conditions or creating procedural protections, due process rights establish the standards for justifying dismissal. The right to due process is opposed by four arguments. 1. Due process entails an illegitimate constraint on people's freedom to set their own working circumstances. 2. If employees have the freedom to leave for any reason, employers should have the same freedom to terminate employees for any reason. 3. Due process and illegitimate constraint on company owners' property rights. 4. Without the threat of being fired as a motivator, employees will become inefficient and unproductive. Patricia Warhin responds to the first two arguments by pointing out the significant inequality between employees and employers. Warhin points out, in response to the third argument, that property rights in the workplace do not include employees. With regards to the final argument against due process, if the cost of economic efficiency is the violation of employee rights to respect, autonomy, and fairness, then we must conclude that efficiency be sacrificed. Due process does not guarantee an unqualified right to a job. Workers provided with job security and due process can be more productive than those without.
Participation rights. John McCall offers 5 arguments to defend the claim that employees have a right to participate in managerial decision making. 1. The fundamental right to be treated with respect. 2. The impartial promotion of human welfare. 3. Creating conditions of employee self-respect. 4. Creating conditions to prevent mental and physical harm. 5. Creating an environment that will foster political participation. There are 3 objectives to McCall's proposals. Those are employer property rights, managerial expertise, conditions of efficiency. Employee health and safety. Protecting employee health and safety is one of business major ethical responsibilities. This is a complicated issue. Health and safety have instrumental as well as intrinsic value. Acceptable risks need to be defined. Several problems. Paternalistic attitudes toward employees. Assumption that health and safety are preferences that can be traded off. Assumptions that workplace risks and other type of risks are equivalent. A free market approach is based on the faulty assumption that markets are perfectly competitive and free. Employees seldom possess perfect information required by markets. Individual consideration ignores social justice and public policy. Occupational safety and health administration. Technological feasibility and economic feasibility. From the perspective of OSHA, industries that cannot operate without harming the health and safety of its employees should be closed. From the perspective of OSHA, even if a standard is technologically and economically feasible, it would be still unreasonable and unfair if the benefits did not outweigh the costs. Cost-benefit analysis and cost-effective strategies. Employees have a legitimate ethical claim on mandatory health and safety standards within the workplace. Privacy in the workplace. George Brinket argues that informational privacy involves a relationship between two parties and information about a third. Privacy is violated only when one of the people in the relationship comes to know the third party, while the other party does not. With regard to the control of personal information, a violation of privacy exists only between those having a personal relationship. What is the nature of the relationship between employer and employee? Employee privacy is violated when employers infringe upon personal decision irrelevant to the employment contract. When personal information irrelevant to the contract is collected, stored, or used without the informed consent of the employee. Thank you and have a nice day.